A federal appeals court just detonated something inside one of the most powerful legal institutions in the United States government. Not figuratively, not rhetorically, operationally. The kind of detonation that doesn't make a sound on the day it happens, but collapses the structural load-bearing walls of a legal defense over weeks and months in ways that no press statement, no background briefing, no presidential social media post can reverse or even slow down. The clerks didn't see it coming. The senior staff didn't see it coming. The political appointees who spent 3 months constructing what they were certain was an airtight appellate strategy didn't see it coming. And now they are standing in the rubble of that strategy trying to explain to the public that the building is still standing while a federal judge has already published exactly what the demolition crew found inside the walls. I have been inside this ruling since the moment it dropped. The language on page 9 required 4 reads. Not because it was dense, because it was a scalpel. Every word placed with the precision of someone who knew this opinion would be read by appellate panels, by congressional oversight staff, by inspectors general, by historians, and by every future attorney general who needs to understand what happens when the internal machinery of the Justice Department gets exposed to judicial light. The court saw what it needed to see. It wrote what it found. And what it wrote is now permanent in a way that no appellate victory, no executive order, no personnel change can reach or erase. Here is what the coverage is missing at a scale that borders on institutional negligence. Trump's response didn't come through counsel. It didn't come through the DOJ press office. It didn't come through any coordinated communication process that should govern public statements by the executive branch in live high-stakes federal litigation. It came through the feed at 11:47 in the morning on a day when his own Department of Justice was supposed to be projecting stability, projecting legal confidence, projecting the image of an institution that had reviewed the ruling calmly and had a measured appellate strategy ready to execute. Instead, the president called the evidence fabricated, the sealed evidence. The evidence a federal judge reviewed under seal, analyzed in a 47-page opinion, and described in language precise enough to function as a permanent institutional anchor. The evidence his own legal team's 31-page opposition brief spent exactly 2 pages attempting to contest before pivoting entirely to procedural grounds because contesting the factual record directly was a fight they calculated they could not win. When your principal publicly calls the factual record fabricated at the precise moment your legal strategy depends on not contesting that record in court, that is not a communications problem. That is a 5-alarm strategic collapse happening in public in real time. And every judge, every clerk, every senior attorney, and every chamber this defense team walks into for the next 18 months is now carrying that public statement into the room with them. Like and subscribe right now. Because when this circuit moves, it will move without announcement. And what it says when it moves will be buried in language that takes training to read. I will be in the filings so you don't have to be there alone. Now, the architecture of how this collapsed, because the collapse didn't happen on Friday. Friday was just when it became visible. 11 weeks ago, this was a legal fight with defined parameters. State attorneys general making structural claims. A coalition brief that the DOJ's initial legal team assessed as aggressive but ultimately manageable. The theory being advanced that DOJ decision-making reflected predetermined political orientation rather than independent legal judgment was serious. But it was also the kind of serious that federal courts approach with enormous institutional skepticism. Courts do not like inserting themselves into executive branch prosecutorial discretion. The doctrine is old. It is protective of the executive for foundational constitutional reasons that serious legal minds across the ideological spectrum have defended for generations. The DOJ's initial defense relied on that skepticism with discipline and with genuine constitutional weight behind it. Whatever you think about the policy choices this department made, courts don't supervise how the executive branch prioritizes cases. That is not a role the judiciary plays. Separation of powers is not a technicality. It is a load-bearing commitment of the constitutional order, and removing it has consequences that extend far beyond any single administration or any single dispute. That argument held for 7 weeks. Then the sealed evidentiary phase produced what it produced, and the real argument met the real record. And the real record was worse, significantly worse, than anyone outside that sealed proceeding was prepared for. Because here is what courts do not do when they review internal executive branch communications and find ambiguity. They do not issue structural injunctions. They do not describe internal strategic discussions as reflecting political outcome orientation rather than legal outcome orientation. They do not write 47-page opinions building a factual edifice brick by documented brick across pages that read like a judge who read everything, understood everything, and decided the public needed to know exactly what he found. When a court does those things, it is because what it read was not ambiguous. It was clear. And what was clear was not what the DOJ's public posture had been describing to the press, to Congress, or to the American public. That gap between the public posture and the sealed record is where Bondi's defense didn't bend. It shattered, not because of legal argument, because of documentation, because someone kept records and a judge got access to them and then told the world what those records showed. Now Bondi's legal team is operating inside a reality they did not model and cannot easily navigate out of. The procedural off-ramps they built their strategy around assume a factual record in contest. The factual record is not in contest in any meaningful way. It has been read. It has been described. It is now permanent. Here is the personal exposure dimension that the coverage keeps softening in ways that are almost certainly wrong. The ruling does not name Bondi in its operative language. This has been reported repeatedly and somewhat misleadingly as a form of legal protection, as though the absence of her name from certain pages means the ruling is not really about her. It is precisely about her. What footnote 29 does is what careful judicial drafting always does when it wants to make a factual connection without extending the ruling's operative reach further than the case requires at this stage. It anchors the structural findings to the period of her leadership with language specific enough to function as a permanent reference point without making the ruling personally about her conduct in ways that would invite different appellate arguments on different grounds. That is not protection. That is precision. And the distinction matters enormously because her exposure is not criminal in this moment. It is not regulatory. It is not the kind of immediate personal legal jeopardy that generates dramatic headlines. What it is permanent. Footnote 29 of a published federal court opinion is now part of the public record in a way that does not expire, does not require a subsequent criminal proceeding to activate, and does not need a congressional majority to become operationally significant. Every oversight proceeding, every inspector general inquiry, every congressional hearing that touches DOJ conduct in the affected categories going forward now has a judicial reference point. A finding, a description of internal communications reviewed by a federal judge and characterized in specific published language. That footnote will be cited by people who had no part in this proceeding in contexts that have not happened yet, making arguments about patterns of conduct that this ruling helps establish across a timeline that extends far beyond this administration. The personal damage is not the legal proceeding. The personal damage is the institutional record, and that record is written. Comment below if you understand what that means for every attorney general who comes after her. Because this ruling is not just about Bondi. It is about the office. It is about what the office can and cannot do when a federal judge decides to read the internal mail. Now the chaos, because that word is appearing everywhere in coverage that treats it as political color, as dramatic texture, as the kind of interpersonal disorder that fills cable segments during commercial-free breaking news hours, that framing is dangerously wrong. The chaos that is actually happening is operational. It is procedural. It is happening inside the decision-making infrastructure of one of the most consequential legal institutions on earth, which is now simultaneously operating under judicial oversight and being publicly described by its own principal as the victim of fabricated evidence in a proceeding where the evidentiary record is sealed and supervised by the judge who imposed the oversight. Think about what that means for the career attorneys in the affected divisions right now this week. They are making decisions about active cases in the monitored categories. Every decision now carries a documentation requirement. Every documentation requirement is being constructed in the awareness that the judge who designed the monitoring framework already read the previous internal communications and described what they showed as predetermined political orientation. They are not making decisions the way they made decisions 6 weeks ago. They cannot. The environment changed around them in ways that make the previous operating assumptions not just unreliable, but potentially dangerous to rely on. When the operating assumptions inside a major institution become unreliable simultaneously across multiple divisions, what you get functionally is exactly what the coverage is calling chaos. Except it is not drama. It is institutional friction generated by the collision between a required new mode of operation and the people, processes, habits, and incentive structures built around the old one over years and, in some cases, decades. That friction has costs. Cases slow. Decisions that previously moved through the system with established velocity now require documentation and review layers that did not exist before. Parties in those cases, companies, advocacy organizations, communities, individuals waiting for resolutions, are absorbing those costs in real time while the appellate process plays out on a timeline that answers to no one waiting for anything. The friction is not abstract. It has a human cost distributed across every matter in the affected categories. And that cost is being paid right now by people who have nothing to do with the politics of any of this. Here is what I need you to sit with before we get to what comes next. What the district court constructed with this ruling is something that will be studied not because of the political noise surrounding it, because of the legal architecture itself. A court that found documented evidence of predetermined outcome orientation in the internal communications of a cabinet-level department and responded by designing a monitoring framework calibrated with surgical precision to the specific nature of the violation. Not too broad, not punitive in form, targeted, documented, built with a review mechanism that allows the court to assess whether compliance is substantive or theatrical at every stage of the 18-month window. That is a judge who wrote this opinion knowing it was going to appellate review and constructed it to survive. That is also a judge who knows that future courts evaluating similar claims in similar contexts are going to read this opinion for the next generation of federal litigation and either build on it or distinguish it. Either way, it becomes the reference point. Every future administration, every future attorney general, every future senior official making decisions about how to approach a category of cases for reasons running adjacent to the legal merits. They are all going to know that this happened. That a federal court obtained access to the internal communications, that it read them, that it described what it found in a published opinion that will be cited in briefs, argued in proceedings, and referenced in oversight contexts for as long as federal courts operate in this country. The assumption that the inside of those conversations is invisible to scrutiny was tested here. It failed catastrophically. The documents came out, the judge read them, the opinion described what they showed, and that changed something that cannot be unchanged. Not just for this administration, for every administration that comes after it across a timeline, no one in that building this week is thinking about because they are too focused on Wednesday. Here is what Wednesday tells you, and here is what to watch for specifically. The compliance conference is on the docket. What the docket entry after that conference produces tells you immediately which approach the department has chosen. Additional submission requirements and detailed scheduling orders tell you the judge sees substantive engagement. Vague continuances and procedural delay requests tell you the department is attempting to run out the clock on a judge who has already demonstrated he knows exactly what running out the clock looks like and built the monitoring framework specifically to detect it. The speed and the language of the emergency circuit petition, if one materializes, tells you whether the appellate strategy is about winning or about buying time. A circuit that sees genuine constitutional weight in the separation of powers argument asks for full briefing. A circuit that sees a petition as legally insufficient on its face moves fast with limited briefing. Fast movement narrows the remedy question. It does not close the factual record. The most favorable appellate outcome this defense team can achieve is a narrowed injunction. It is not an erased finding. It is not a sealed footnote. It is not a retroactive revision of what a federal judge read in those internal communications and decided the public had a right to know. And whether anyone inside the affected division speaks through background channels about the internal compliance process in the next 60 days. 9 months is a long time. Institutional friction under this kind of pressure has a documented history of surfacing in ways that reach public view, regardless of what the communication strategy at the top of the organization intends. If the documentation requirements are being met in form but not in substance, that information tends to find its way out. The judge who designed this framework to detect exactly that failure will be sitting across from the compliance record with 18 months of documentation and a demonstrated ability to tell the difference between real deliberation and performed deliberation. He showed everyone already that he knows the difference. He showed everyone in 47 pages of published opinion written in the precise language of an institution that has decided it has seen enough and intends to say so in terms that last. Like this. comment, subscribe, turn on notifications. Because this circuit moves without warning, and what it produces when it moves requires the kind of reading that the breaking news format does not have time for. I will have time for it. I will be in the footnotes. I will be in the docket entries that publish at 4:47 on a Friday afternoon when no one is watching the feed. Here is where everything stands right now as of this moment. A federal court issued findings that the United States Department of Justice under Pam Bondi made litigation decisions reflecting predetermined political outcome orientation rather than independent legal judgment. It backed those findings with sealed internal communications that a judge reviewed, analyzed, and described publicly with specificity and precision. It imposed 18 months of structural judicial oversight on a defined and consequential category of DOJ decision-making. It stayed 3 specific matters. It gave the department 60 days to demonstrate substantive compliance with a framework designed by someone who already knows what theatrical compliance looks like. The president publicly called the evidence fabricated, while his own legal team's filing spent 2 pages on the factual record before pivoting entirely to procedural grounds. That gap between the public statement and the legal strategy is not a messaging problem. It is a strategic incoherence now documented in the public record that every chamber this defense team enters for the next 18 months will carry into the room. Bondi's name is in footnote 29. Footnote 29 is in a published federal court opinion. That opinion does not expire. It does not require a criminal proceeding to activate its damage. It does not need a congressional majority to become the reference point in the next oversight hearing, the next inspector general inquiry, the next adjacent litigation, where the pattern of decisions made inside that building during this period becomes relevant to a claim someone is making about something that has not happened yet. The record is written. The assumption that the internal deliberations were invisible was tested, and it failed. And every meeting happening inside that building this week is a different meeting than the ones happening 3 weeks ago, because the people in those rooms now know what happens when a judge decides to read the record of meetings like theirs. That knowledge changes behavior, or the 9-month review is going to show that it didn't. And the judge who built the monitoring framework to detect exactly that failure will be ready with 18 months of documentation and a very precise sense of what he is looking at. He showed everyone in writing, permanently, in a published federal court opinion that will be cited by people who have not been born yet, making arguments in proceedings that have not happened yet about questions we have not fully articulated yet. Wednesday is next. September is after that. The 18-month clock is running and the appeals court has not spoken yet. Stay in the documents. The story is in the record. It always has been and it always will be. Subscribe. Notifications on. I will be in the footnotes. Because that is where this is actually being written. Not on the feed. Not in the briefing room. Not in the press statements projecting confidence. In the footnotes. In the sealed submissions. In the language a federal judge chose with extreme care when he decided the public needed to know exactly what those internal communications showed. He made that choice deliberately, in writing. With 18 months left on the clock and a compliance conference on Wednesday and an appeals court that has not yet told us what it sees when it looks at all of this from the altitude it operates at, I will be there when it does. I will tell you what it means before the coverage catches up to the filing. Because that gap between the filing and the coverage is where the real story lives, and I intend to live in it with you until this clock runs out.